Hello folks, it's Chandler Anderson. I'm sitting down tonight with Robert Dalton Jr., the candidate for Public Defender in the 17th Judicial District. I wanted to sit down with Robert and ask him a couple of questions here to kind of define what the role of the Public Defender is, and also to talk to him about what his goals are when he takes office as Public Defender. And also, what are some of his constitutional beliefs and how he believes the Constitution should be upheld within the office of Public Defender. So Rob, what is the Public Defender office? What does it do?
Well, the Office of the Public Defender has two primary responsibilities. The first one is the one that people are, I guess, the most familiar with, and that's to defend people who can't afford counsel. Now, not being able to afford counsel, though, is a very fluid concept, because if you, let's say that you're charged with a traffic offense. Well, maybe in that case you can't afford a $250 lawyer. Or if you're charged with, say, let's say that somebody comes into your house in a home invasion and you're forced to defend yourself with a weapon, and maybe you get charged with attempted murder or something. Well, in that case, maybe you need a $50,000 lawyer, or maybe you need a $100,000 lawyer. So the scope of representation of the people that we think of as being unable to afford counsel is actually a lot bigger than most people think. The second primary component of the job is that the public defender is the one position in the judicial district whose job it is to be the primary constitutional educator. Public defender needs to be going around and explaining to the general public, to legislators, to school staff, and to people in our community about why the Constitution is important and how it was a good idea then and it's still a good idea now. We see on a daily basis where there are lots of people in the country right now who appear to be under the idea that various parts of the Constitution are outdated or something else, and I find that that's usually because they simply don't understand them. They don't understand why they're important, and they don't understand why it's a good idea going forward. So those two responsibilities are the primary responsibilities. Of course, there are others that are laid out by statute, such as attending meetings and hosting meetings, that sort of thing, but those are really the two primary things that the Public Defender's Office has to do in order to really fulfill its core functionality.
Okay. I think that certainly explains it so that people kind of understand why this election is important for the everyday person. You know, why the Public Defender's Office is important. Let's say August 7th, we all go to the polls, and Rob Dalton comes out the winner of this election. How does the Public Defender's Office change based on your beliefs that and legitimate beliefs, I should say, that the Constitution is complete and whole and is not to be dissected? How does the Public Defender's Office function with Robert Dalton as a Public Defender?
Well, I think the first thing that would change would be a focus on competence. Of course, in recent days there have been a lot of news stories, both nationally and in the state of Tennessee, about the effects of what happens whenever you do not have competent leadership in charge of the Public Defender's Office. Well, I think we were all shocked and horrified by the story that was on the cover of the Tennessean, you know, about Randy Mills, and we've all been, of course, I've been personally fighting for the exoneration of Jonathan Tears. So what happens if you don't have competent leadership in the Public Defender's Office is what happens in Randy Mills' case, where you get a person who was innocent and they sit in jail. The taxpayers pay for 13 years. The taxpayers' money was wasted on keeping a man in jail who didn't need to be there. And at the same time, because there was not competent leadership at the head of the Public Defender's Office, for 13 years now, the actual perpetrator of that crime has been out in the world. And that's what happens whenever you don't have innocent people defended properly. We put them in jail and we say, we're done. We're glad we got the right person. But we didn't. And then it turns out 13 years later that whenever we get the DNA test results back, we know we got the wrong person. And we don't even know who did it. We don't know. But somewhere out there, there's the actual perpetrator. And that's the problem. That's the problem of the lack of competence. The other things, so, I mean, that's the biggest thing that's going to change is, you know, we want, it's no good to say, well, you know, look, we're gonna go out here and we're gonna be the public defenders. It's no good to say that if it's not backed up by, and we're going, whenever we step up to defend the Constitution, we're going to try to win.
Right.
I mean, if you're going to stand up there and say the Fourth Amendment is just as important now as it was then, it was a good idea then, it's a good idea now, and you don't even try to win, then who cares?
Right. You know, the job of an attorney in general is to get the best outcome for his client, his or her client, I would say, and
within ethical bounds.
Within ethical bounds,
right?
But if you don't ever even take the opportunity, which is the case in Mr. Mills' case, if you don't ever give it that shot,
right,
to try to win,
it's just sheer laziness. It's just sheer laziness.
Yeah.
I mean, you know, failure in this case. Yeah, you know, but it's deeper than that. I mean, most of it is sheer laziness, but it does go deeper than that. In that it's a kind of pathological sort of mindset in which it's like this weird pathological obedience to the state's authority. If you're going to be the person whose job it is in an adversarial system, and let's be clear about that now, our system doesn't work unless you have competent counsel on both sides. The whole system is based on the idea that if you have competent lawyers on both sides, they're going to get at the truth.
Correct.
And if you don't have competent counsel on one side, then you don't get at the truth. You just get at a result, and a result which could be wrong for 13 years.
Right.
All right. So you've got to have competence there to make sure you're getting the right conclusions in the first place. And I forget what the hell we were just talking about.
We were talking about how the public defender's office would change with Robert Dalton at the helm. But, you know, let me take a side note here and just talk to folks at home. Think about this, folks. You could be accused of something today that you did not do. The police could come and arrest you, in Mr. Mills' case. You could be then given a public defender who has so many cases that you're no longer Mr. Mills, you're just case number 4,382. You have to have a public defender, in my belief, that recognizes this is Robert Dalton, and this is his situation, and I've got to give him the best representation that I can. Folks, the system is broken as it stands. And as Rob was saying, our system's designed that if I have a competent lawyer here and a competent lawyer here, the truth is going to come out because they're both going to do their jobs. And it seems from reading USA Today and the Tennessean that that's not the current case. But let's also go back to what else will change, Rob. You mentioned competence. There will be competence at the head of the public defender's office, but what else will change?
And thank you for reminding me. I now remember where we were. Well, what I was going to point out was that another thing that will change is that the case with Randy Mills also illustrates something else, which is this sort of pathological thing where, like, not only was it sheer laziness where you depend on the other side's expert. Now, if when you go and you read the opinion from the Court of Criminal Appeals, the Court of Criminal Appeals itself has serious doubts about whether the TBI agent who supposedly did this DNA test, which supposedly didn't exclude Randy Mills, about their credibility. The PD's office would have known that had they done the basic thing of fact-checking the state. So you have this weird mindset. You have an office where they don't file formal discovery because they think that the state will just give it to them. It's this weird mindset of where, unlike in every other aspect of the law, where we, as lawyers, we have trust but verify, right?
Right.
This is the way you operate. Except in this office right here, it's just trust. No verify, just trust. The state's always going to do the right thing. Well, if they've already charged and accused an innocent man, then you know you're starting out with they're not doing the right thing. And that's the whole point. But if you don't have somebody over there who's skeptical about the exercise of state power, and of course that's what the purpose of the Constitution is. The purpose of the Constitution is to limit state power precisely because the state as an actor in the world, the government as an actor in the world, is not always right. It's not run by some benevolent overlords, right? Which is exactly why we need restrictions on their ability to come down and tell us what we can and can't do, and whether or not we can own firearms, or whether they can bust into your house and search all your stuff. So it's that kind of mindset, that kind of weird idea that the state and the government is your friend and they're there to help you. That's sort of that old joke, hey, they knock on the door and say, hey, we're from the government, we're here to help you. That's not true. When they tell you that's not true. So, but it's that sort of weird thing. That would definitely change. That's a cultural shift, and it'll take time. But you have to do that in order to build the spirit of resistance that's necessary for the public defender's office, in addition to basic core competence in terms of actually filing discovery motions, actually filing suppression motions, like in the Holly Hunter case, and it just goes on and on. Just really bread and butter, basic stuff that's not being done every day, that is done by any competent criminal attorney, that's simply not being done if you're a poor person in the 17th Judicial District.
And one thing, Rob, that you've always said to me, and I firmly believe, it doesn't matter your race, your financial status, your religious belief, none of that matters. Every person that is a citizen of the United States deserves adequate representation. And that's one thing you said at the very start of this campaign, is that's one of your goals, is to make sure that it doesn't matter how much money you have in the bank,
right.
It doesn't matter where you're from, it doesn't matter who your parents are, it doesn't matter which church you attend,
right.
You deserve adequate representation. And one thing that that I practice, and I think you've mentioned this before, there's the Jerry Maguire effect. You can run 5,000 people through your office. In my case, as a medical person, I could run 5,000 people through my office, but what quality of care are they getting?
Right.
If we run 5,000 people through the public defender's office, well, there's only so many hours in the day, and so you have to kind of take that caseload down. You can't say, hey, let me have as many cases as I can handle, or
right.
that I feel like I can handle. You have to have some limit there. Do you foresee the public defender's office kind of taking a step back and saying, we want to do these things. We want to file discovery. We want to file suppression when it's appropriate. We want to take time to not do the meet and plead process that we currently have in place.
Right.
Do you see that that's one thing that may change with you?
Well, I don't really think that this is really my choice. I actually don't think that it's Donna Hargrove's choice either. There are limits. There are guidelines that are issued by various professional organizations on both the national and the state level, and they're very clear. You shall not exceed these limits, and if you do, then you are going to start having degraded service to your clients. So like I said, this is not something I don't have to sit around and figure out what this cap is. These are well-defined limits. Now, the problem is, of course, that if you go over those limits, then you're going to render worse service. You're going to have worse quality of service. But you're also going to wear your staff down, of course. I mean, but you're also going to develop this culture in which all you're trying to do is grind people through your system. And that's what you were just talking about, this meet and plead thing, where the first time you ever meet your attorney as a citizen accused of a crime, the first time you ever meet your attorney is the day that they tell you that you've got to plead guilty. And if you don't plead guilty, then they get real mad at you and bring you back another day where they can try to berate you into pleading again. Well, that's ridiculous. I mean, that is not playing the role of defense counsel. That's not playing the role of defending the Constitution. We defend the Constitution in the form of individual clients, in the form of individual defendants. We can't just, in a vacuum, just go to the judge and say, Judge, look, we really think the Fourth Amendment's a good idea, and the state really ought to stop violating it. You get an individual person in an individual situation with specific facts, and then you have to go in there and explain why it is that the Fourth Amendment or the Second Amendment or whatever covers this specific set of facts, and why the general rule should apply to this specific situation. And you can't do that if you don't have a proper orientation, if you don't have this idea of, well, we're going to go in and we're going to defend the Constitution on this specific set of facts, because you don't remember them, right? I mean, you have too many cases, you can't even recall what facts these are, right?
Right.
And suppression motions, well, they take time.
Right.
You have a suppression motion, may take half a day, may take an entire day. But that's some of the most important work we ever do, because that's the time whenever we are able to communicate to the court, to our client, to the public, that, this simply is not allowed. The state cannot itself violate the law while it's trying to uphold the law.
Correct. It sounds like the public defender's office, under the Robert Dalton regime, we could say, is going to get back to what it was meant to be to start with, and that is the defender of the Constitution, rather than kind of a cow meal that just runs people through and they lose their identity, and it's, oh, well, what is this person here for even? Right. It's going to get back to that personal level of representation.
Chandler, that has been one of the most surreal things on the campaign trail, is to hear my opponent regularly and routinely brag about how many clients are forced through her office every year. She says it proudly. And the truth of the matter is, of course, is that those people are receiving absolutely the lowest level of services, to the point where we have people like Randy Mills and Jonathan Tears and all these other guys who are receiving not just a low level of service, they're receiving such ridiculously incompetent level of service that they're deprived of a fair trial.
Right.
And so they have effectively lost their right to counsel as a result of this. And yet, over and over again, she brags and says, yes, we have this many thousands of people coming through my office every year. That's not something that a person in her position should brag about. What you should brag about is the quality of your representation, not how many you did.
Right.
Anybody could lose 5,000 cases a year. That's a no-brainer.
Right.
Talk to me about your success in defending the Constitution and what you've done to advance the Constitution in our judicial district, not just merely that you pushed X number of heads through the door.
Right. And for me, again, going back to a medical perspective of this, if I push 5,000 people through my office in a month and I misdiagnose 5,000 people, well, what have I done?
Right.
And one thing that, I've heard rumblings of is, well, she's an incumbent and she's been there for 16 years. Why should we change this? You know, I think ultimately, let's talk about the elephant in the room. Yes, your opponent has been in office 16 years.
That's right.
Within those 16 years, how many landmark cases has she won and shown her dedication to upholding the Constitution? Like, how many of these, when you went through law school, did you read about Donna Hargrove has upheld the Constitution in this case? Surely, in 16 years, I mean, for me, I've been doing what I've been doing for about 16 years as a nurse and MP, and I can tell you, I can recall times that I caught really weird stuff. So surely as an attorney, what are her landmark cases that she upheld the Constitution and that you've heard about coming out of Marshall County?
Or, well, not just Marshall County, but any county. Zero. None.
So there's no landmark cases?
No, of course
out of 16
not.
years?
Of course not. If you don't try, you will never win. You've got a person currently in the Public Defender's Office in the 17th Judicial District who views trying itself, trying to win, is a sin. Trying to win is bad because it means that you get fewer heads out the door. Every time you have a suppression hearing, every time you file a discovery motion, that means that that's one less head out that door. You've got a pathological culture in that office right now. The whole idea, the fact that, see, you and I, of course, look at that situation and we say, well, that's ludicrous. Surely in 16 years, we would be able to discuss their victories. We would be able to say Donna Hargrove won the case.
So there's been no landmark victories?
No, of course not.
How many victories have there been that you know of?
Donna Hargrove? Yeah. Zero.
In 16 years.
Of course, if you don't play, you can't win.
Rob, sometimes when we do these, we go back and forth and they're kind of ribbing me and joking with me. Look, honestly, none in 16 years?
No. And as a matter of fact, this is another thing that really irritates me about, like, one of the things about being on the campaign trail is that you actually spend so much time with your opponent, listening to them talk. And she's fond of saying, I have been involved in 3 death penalty cases. Been involved in, okay, that's a nice euphemism. Let's talk about, that's sort of like those other 5,000 heads.
So she trialed. So she did go to trial for 3 death penalty cases?
I was involved. Well, you can't really agree to settle. Your guy, it's very rare that your guy would say, "Oh yeah, I'll take death." So that's
true.
But this is the kind of thinking. Like, I've been involved in these cases. Well, that's nice. It's nice that you were involved in them. You were present and breathing apparently during the proceedings. What happened? What happened during those cases, right?
So you were involved, but you promptly lost.
And so this is the thing. It's like my office is involved with 5,000 cases a year. Well, that's wonderful. What happened in those cases? Merely being involved in the case. You talk about like these sort of euphemistic, let's the brutal honesty here. Involved in doesn't count for anything. It'd be like if you were seeing patients in your clinic, and they come in, you looked at them and you said, you seem fine to me, and you check them off and you send them out the door and you say, well, I was involved in their care.
That's true.
It's like,
but I didn't really do anything.
You didn't do anything.
Right.
You just sat there with a pulse,
Wow.
And you were involved in it.
I genuinely am amazed that in 16 years there's been no Donna or Hargrove victories. So,
well, I tell you what. You don't have to take my word for it. The Court of Appeals has all their opinions online. Go look for one. Google is your friend. And I can tell you, I've done this. You know, landmark cases that come out of the 17th Judicial District. We've had some, but not from Donna Hargrove. I mean,
Wow.
we do have some. We have good attorneys in this district, and we have had some interesting criminal cases come out of here, but not from Donna Hargrove. I mean, the very idea is ludicrous. I mean, if you don't play, you can't win. It's not complicated.
Rob, let me take a side note again and talk to the folks at home. Okay, folks, let's wow, no victories in 16 years. Let's talk about this. We kicked Jeff Fisher to the curb because he didn't have a winning season. He won some games, but he didn't have a winning season.
He didn't win enough.
He didn't win enough. And if you took your car to a mechanic for 16 years and never figured out the problem, would you keep going back, folks? The other thing, let's put it in my shoes. You come see me and I get it wrong for 16 years, I would tell you need to see someone else. And we constantly say that it's time for a change in politics and this and that. These people are losing time with their family. Folks, we lose people on this earth every day. Mr. Mills lost 13 years with his family.
Yeah, these children are losing their parents to jail.
Yeah, because
they lose their whole childhood. You know, Mr. Mills is a tragic example of that. His son actually died while he was wrongfully incarcerated.
Wow. And there's no amount of money, there's no amount of I'm sorry's, there's no amount of anything that can replace that. You know, it would be interesting to me, now that I've found out she hasn't won a case in 16 years, that has she apologized to Mr. Mills? Has she issued a formal apology for failing him as the public defender? I feel like I would have to do that if it were me, to say, oh my goodness, Mr. Mills, I failed you. I'm sorry. Has that occurred?
Well, that's a good question. I was interested whenever the story was on the front page of the Tennessean, and whenever the story was in the USA Today.
And it's not easy to get a story in the USA Today.
Oh my gosh!
I mean, there are,
and during an election cycle with that,
right?
I mean,
My goodness.
Most people would be like, "Oh, that's you know, yes, I'm in the USA Today." But I was really curious, you know, what her response would be given the horrific circumstances around Mr. Mills' case. And I was shocked whenever she was confronted about this at a recent event, and rather than apologize, rather than say, you know, look, I realize that we made a mistake here, a mistake that has been recognized by the courts, that's been recognized by the press, an obvious, on its face, horrible mistake, and we're going to fix it, and we're going to get better. Now that's what I would have expected her to say. That's like what a reasonable person would say.
Well, that's what a reasonable person
Right.
would do, yeah.
I was shocked at her response, which was essentially, well, I still think he's guilty. In the face of the DNA,
Wow.
in the face, and she starts off her response saying, well, you know, he was found guilty by a jury. Well, of course he was. The jury was never told
Given
the
information,
truth.
yeah.
That's right. So if you were sitting on that jury, that's what I say. It was completely unfair to the jury. It was unfair to the taxpayers because it wasted their money for 13 years keeping a man in jail while the other perpetrator was running around. It was unfair to the jury. The jury sat there and had to make a decision about sending a man to prison for 20 years and weren't given the facts. They didn't know. They didn't know that the DNA that was actually there, that the evidence was actually there, said it didn't happen. So, of course...
So they couldn't make an informed decision.
No. So, of course, you know, and right now, I mean, you can imagine, if I had been on that jury 13 years ago,
Wow.
I would be so upset about this. But yet it's not their fault, because there wasn't competent counsel on the part of the defense. The jury was simply never given the information they needed to make a good decision. It's not their fault.
Right.
But the fact that she would then stand up there and say, well, he was convicted by a jury and all this kind of stuff, and then go on and just went on and on, just for minute after minute of her essentially saying,
blaming the victim.
Yes, exactly, blaming Mr. Mills and essentially saying that he was guilty. Even though we now know beyond, like, you know, it's this sort of crazy anti-science thing, you know, like, we know it's a scientific fact that he did not rape this child. And yet, still, she's so immune to accountability and so immune to responsibility after 16 years of nobody challenging her that she just can't, she doesn't seem to be able to internalize, I messed up, but I'm gonna get better.
Right, right.
She just cannot seem to get it into her head that not only did she do something horrific to this poor man, but that it demands improvement. And you know, you can't improve if you can't even accept that you've done something wrong to start with.
Well, and that's the thing with mistakes. You have to learn from them, but you have to take accountability and again, want to learn from those mistakes. Well, Rob, I thank you for sitting down, and we'll do this again as the election, you know, the campaign trail continues. I think people want to hear more from Robert Dalton. Folks, I would just implore you to think about this. As you watch this, and when you're done and you click the right upper corner of the screen and you're done, go in the living room and look at your children. Go in the living room, look at your wife, look at your parents, and think about a human being who's a police officer who can make a mistake because they're human. Makes a mistake. You end up arrested. And the person that's supposed to save you, your knight in shining armor, tells you that you're guilty when you know you're not. Folks, that's what's going on right now. Listening to Rob, you can tell. That's what's going on right now. Somebody essentially telling you, I don't have time for this. I don't have time to make sure that you don't go to jail because I've got to run these other people through so I can wave my flag to say I see 5,000 cases a year. Folks, divide that out. Divide 5,000 out by a 40-hour work week. My goodness, as you can tell, that's a whole lot of cases and a little bit of time for each one. Look at your kids, look at your wife, look at your parents, and think about if I found myself in need of a public defender, do I want to be case number 4,366, or do I want to be Mr. John Smith, who has 3 kids, who has a mother that he's taking care of, who has a wife that depends on him? Folks, August 7th is quite possibly the most important election date in the 17th Judicial District's history. That's the day when the Constitution returns to the forefront of the Public Defender's Office. That's the day that you have an opportunity. And folks, you may be sitting there thinking, you know what? I got enough money. I got enough money for a lawyer if I need it. I own a business. Well, let's say this. If you own a business, think about the folks that work for you. Do they have enough money for a $100,000 lawyer? Probably not. My employees don't. I don't. Think about the folks who need the Public Defender's Office. Think about your brother, your cousin, you know, somebody in your family undoubtedly would need the Public Defender's Office if they were wrongfully accused of something. Folks, after this discussion, I firmly believe this man here, Robert Dalton, is the change that is needed for the Public Defender's Office. It's time for us to turn the page on the antiquated practices of Donna Orr. I'm still stunned that in 16 years, not one case has been won from her office. Folks, it's time for a change. It's way past time for a change. It's time for competence. There's another C word. It's time for the Constitution and it's time for competence to be restored to the Public Defender's Office. Folks, you see the website address here on the bottom of the screen. Visit Robert Dalton's website. Look into what he's gotten there on the site, what he has there on the site, and what his beliefs are. And folks, if you have a question for Rob, give him a call. Rob, what's the number they need to call if they have a question that they want to talk to you about as far as what would you do as a public defender?
931-359-8143.
Folks, you'll see that at the top of the screen here. Rob,
And I just want to say, Chandler, that's my personal home phone number.
wow.
And people are welcome to call it. One of the problems with the office currently is that there is absolutely no transparency. The families of the accused are never able to find out basic information about court dates or anything else. We're going to put an end to that, and we're going to start putting an end to that during the campaign season. People should feel free to call us, and if they have problems, questions, issues, we'll address them.
Folks, that's an attorney giving you his home phone number. Think about that. How often have you ever seen that? Rarely. Rarely have you ever seen that. Folks, it's time to take our county back. It's time to take the 17th Judicial District back. It's time to take back our freedoms that are ensured by the Constitution. Folks, we appreciate your time. We know this took a little bit of your time, but hopefully you know more about the man, Robert Dalton, and you know more about the Public Defender's Office. Again, August 7th, when you enter that election, when you enter that voting booth, make sure that you see Robert Dalton's name and that that's who you choose for public defender. Because it may not be you, but somebody in your family may end up needing a public defender, and they deserve the right to fair and competent representation. Folks, thank you for your time, and we'll be back with another edition of Talking with Robert Dalton very soon.